Good morning, everyone, and welcome back to MacDonald and Associates monthly webinar that we are trying to do every month in order to provide you with an opportunity to ask questions and answers about those topics that we prepare that we think are relevant in today's workplace. Now, I have to let you know, if you have any questions, please do send them to us at social media at macdonaldassociates.ca. Specifically, I'm very happy to try and answer them as we go, and if not, I'll try and get to them after. But as usual, I have chosen a topic, and I chose this topic for this month because I feel that it's imperative that we speak about a concept called fairness and being reasonable in the workplace. And the reason I feel so strongly about that is I feel that we are starting to reach a point in society where we are forgetting or omitting certain civilities, certain courtesies. And I fear that we're getting into a world where we're forgetting what it is like to be fair to someone and reasonable. To start out with, I think it's important that we all remember that employers have every right to expect that an employee will in fact work for the employer and in fact carry out the duties and responsibilities that they have been hired to do. So performance management is one of the things that an employer can do as long as the employer is doing it fairly and reasonably. Likewise, employees, as you know, you have a duty to carry out those duties and responsibilities for the employer, but you don't have to carry out duties and responsibilities in a poisoned workplace, in a toxic workplace, in a workplace that is rife with sexism, racism, homophobia, in a workplace where you're being bullied or harassed. You have certain rights in that respect, but the basic rights of employers and employees is to employ employees to do work for employers and to do it in a manner that the employers expect with professionalism and dignity, and that goes both ways. And I know this sounds trite because we talk about these concepts a lot, but I feel that we really need to dig down into what is fair and what is reasonable. Performance management is often one of those topics that turns from a very legitimate reason of performance management well into bullying and harassment, and it doesn't need to. There may be occasions where, in fact, unfortunately, your managers are bullying and harassing employees, and there are very legitimate actions to be taken if that is the case. And employees, you have every right to complain about it. But if the employer is reasonably giving you standards by which to work, it is very important that the employee carry them out. One of the things that I fear that we also forget in starting to conduct performance management in the workplace is we want to put everything on paper, but we seem to omit the very simple concept of verbal communication with the employee. I like to recommend to my employers before we commit to paper that they sit down with the employee genuinely and have a discussion about what the performance issue is. I think it's important to approach that discussion by way of constructive criticism, but I think it's equally fair to point out what the employee is doing wrong, how the employee can improve, and what you're going to do to help that employee to improve. Employees, you're not perfect. You may not be carrying out your duties and responsibilities in a manner that, in fact, the employer believes needs to happen in order for the employer to have a successful workplace. As such, you need to be able to listen to what the employer is saying and allow the employer to explain to you what is happening and why this is a problem. And then you are permitted to respond. Now, what I have seen as an employment lawyer in particular for the last 18 years is things going terribly awry. And they're going awry because the approach of the employer may be wrong. The approach of the employer might be completely confrontational and not constructive. Likewise, the response of the employee may be completely contradicting everything the employer says, blaming the employer. And so I fear that what happens is the communication that needs to exist to get the job done is lost. Communication is the essence of any good relationship, most of all, employment. You cannot possibly expect your employees to do what you want them to do if you don't tell them what to do. And employees, you have to be receptive to that. If the employer decides that, in fact, the employee is, for example, not attending work on time, and yet they are contractually obligated to do so, and that it is causing a problem in the workplace, the employer has every right to be able to tell that employee that they need to begin to reattend the workplace at the time they're supposed to be there, and it needs to improve immediately. If there is another issue at hand, the employee can raise it at that point, and the employer has the ability to be able to consider what the issue is and to be able to act legitimately and fairly and reasonably. But certainly, if the employer decides and has decided in hiring the employee that they need that employee in the office by 8:30, that employee should be in the office by 8:30, absent a very legitimate reason not to. With respect to performance management, it is not an easy task in today's society because we're all too busy. And I blame technology because technology has made our lives infinitely more complicated, I believe, because of the expectation of the instantaneous response. Unfortunately, we all have to think that the instantaneous response is not possible. I know we all want the instant response, but it's not always possible. In fact, 9 times out of 10, it's not possible. You can't be doing a great job on something and also looking at your email all the time. It's just not functional. So if you don't hear from someone right away and you need a response, consider picking up the telephone. Particularly in an office, buzz the person and find out if there is something that that person is attending to that's preventing them from responding to you. Or better still, have a face-to-face. Walk into the person's office and say, I really needed a response on that. Is there something preventing that? Could we chat at a later point? Then you will have diffused the situation. Then you will have had some communication. You'll know what's going on. Employees, you'll be able to tell your employer if there is an issue or something that you're working on to get out, which is a time limited response and you only have a certain amount of time. Let your employer know. As soon as both parties know and understand what the other party needs and wants, you're going to eliminate the need for any type of confrontation. Now, again, performance management is different. If you have an employee who is consistently not doing what you need or consistently not answering you, that's a performance management issue. But absent that, Try and have verbal communication. And when you're doing that verbal communication, that first meeting with the employee, I want employers to really listen. Listen to what the employee is saying. Employees listen to what the employer wants. It's a two-way street for both of you. And that goes not only for performance management, it goes for accommodation as well. If you have a legitimate need to be accommodated in the workplace, employees, you must tell the employer. Employers, you must listen to determine whether or not there is a legitimate need. And there's legitimate supporting documentation to support that need. You can't assume, employees, that your employer will know what you need and what you want if you don't tell them. 9 times out of 10, the way in which to defend a situation where an employer is accused of not accommodating is the employer says, we didn't know. We didn't have knowledge of this. We had no communication from the employee. But again, start it with a simple meeting. You don't need to send an email until after the meeting. Confirm the meeting in writing in a pleasant, courteous way. If there have been issues that you are concerned with, bring them to the employer's attention. If you have someone who's bullying you in the meeting, bring that to the employer's attention by way of HR. Go and see HR if there's an issue with something. But try and make sure that you're always communicating what you need to communicate. Otherwise, you're going to get nowhere, and you're going to have a very tense and, I think, toxic work environment. So many employers say to me, well, Natalie, how do we determine if we need to performance manage an employee? And I always say to the employer, do you want to keep the employee? Is that your goal? Because I have to tell you folks, and you probably have seen from the Gallia case, if you do not want the employee in the workplace and you've made up your mind, don't string it out. Don't make it the long goodbye that Justice Emery spoke about in the Gallia decision. Make it short and sweet. You know you have obligations that if you terminate an employee's employment, you owe them. Pursuant to either their employment contract or under the common law, you owe them reasonable notice. That, unfortunately, is the cost of doing business. However, if you want to keep them, if you believe that they're going to be an asset to your organization and you believe that maybe they're just going through a hard time with a particular performance issue, then performance manage them. But do it fairly and do it reasonably. Don't bombard them with emails. Have that first meeting. Make sure you've got your paper trail for the employers. Yes, you need to, but also make sure you make time for that employee to be able to follow up with you. At law, you can't get anywhere unless you follow an actual ability to show the employee certain standards that they have to meet. And then after that, to be able to follow up and make sure you've met with them so that you've provided them with as much guidance as possible. And even then, you may not be able to terminate for just cause, and likely you won't for performance. But if you do that properly, you certainly are going to ward against any human rights complaints that are going to come your way, or any complaints of bullying and harassment, because you're going to be able to prove a paper trail. And yes, unfortunately, that is what it has come down to in litigation. You need to prove a paper trail. What I'm saying is do it fairly and reasonably. And the more you treat your employees fairly and reasonably, and employees, the more you treat your employers fairly and reasonably, the less you will really need to have such a paper trail to move forward. Now, another question that I'm often asked is in respect of workplace harassment, how does that factor into performance? Unfortunately, what I see is a lot of employees who will in fact be genuinely performance managed, but unfortunately they will turn it into workplace harassment. Likewise, I see very illegitimate performance managements of employees, which will in fact be and should constitute harassment, but the employer sides with the employee or the manager, whoever is doing the performance management in that regard. That's where HR needs to step in and needs to start to look to determine what it is. And you need to be aware of the signs of harassment. You need to be aware of the signs of performance management. Obviously, in your workplace, you should have structures in place so that both employers and employees know the steps that are taken in performance management. Those should be in an actual written document, and you should rely on each and every step. And your document, of course, should be flexible enough so that you can deviate if there's something very serious or very urgent going on. But employees should know, and employers should be able to tell them. You know, in respect of workplace harassment, as we know, you have an absolute duty, employers. Once it comes to your attention, you need to look at it immediately and you need to investigate it. And you need to do so promptly and efficiently, and you need to let the employee know. I have 2 employees currently who I'm representing who both have come to me and said to me, Natalie, I did not know that my employer was even investigating what I brought to their attention because I haven't heard from them. I went to HR, I made my complaint, and I've heard nothing. Well, that unfortunately forces me into a position to have to write to say my client doesn't know what's going on. My client obviously believes the company doesn't care, and therefore I will find ways of saying to that employer that they're going to be responsible for extraordinary damages because they failed to investigate. You can nip that in the bud by actually communicating with the employee and telling the employee that you take their concerns genuinely and legitimately, and you are going to take action to investigate it. You're not making a decision, you're not passing judgment, but you're going to take fair and reasonable actions to move the matter forward. Employees, you can't expect employers are going to investigate this in a day. In some cases, they can. In other cases, it's going to take longer. You have to be patient. If there's a threat of violence, obviously employers are going to have to address that immediately. And employees, you have every right to expect that you are not to work in a violent or sexually charged atmosphere. You have that right. But you also have to allow the employers the time within which to be able to investigate. See, today I feel society has turned into a society of instant everything, so that responses to letters are immediately required. Employees will write to employers at 7 o'clock at night demanding things that have to happen, and the employer may not even know that because they may not be checking their email, and hopefully they're not. Employers, likewise, you can't be giving directions at 7, 8 o'clock at night to employees unless it's extremely urgent. And you can't expect instantaneous responses at night. It's not fair, it's not reasonable, and we're not sustaining our environment. Too many stress claims are coming forward as a result of employees being inundated with these things. It's not right. This is not the way the workplace was meant to function. We're meant to function fairly and reasonably. That's what the courts require of us. That's what we require of each other. And when we don't function that way, that's when problems start. The main issue that courts are always looking at when they're trying to determine extraordinary damages is, was the employer fair and reasonable? Was the employee fair and reasonable? You know, in the case of punitive damages of an employee, where in fact, I believe the case was the RBC employees in Vancouver and Merrill Lynch, where employees left en masse to go and work with another employer, and they almost caused the collapse of one branch of the bank. the courts were very, very intolerant of those employees and awarded punitive damages because they thought the actions of the employees were reprehensible. And the reason they did is because it almost caused the collapse of a business, right? That's something that the courts look at. Likewise, when the courts look at the actual actions of the employer, they're going to measure those on the same level. Are they fair and reasonable? Justice Emery did not find that Walmart was fair or reasonable with Ms. Gallia. And in fact, Justice Emery went much further than that. He found the actions reprehensible and awarded those damages, which, as you know, are $250,000 for the moral damages and $500 for punitives. But that's what the courts need to look at. I had someone ask me for an opinion the other day of extraordinary damages on a particular case. And I'm very clear in terms of my opinion. The courts need to find that they are sympathetic to the employee's plight. They're not going to award extraordinary damages unless they feel a sympathy or an empathy with the employee. The employee has to be liked. The employee has to be likable. It's very difficult to achieve extraordinary damages for an employee who's not likable or not liked, or the court thinks is being dishonest or difficult or not telling an employer all the things the employer needs to know in an investigation. So you have to think of these things before approaching these kinds of concepts. But to avoid these kinds of concepts, you know, in my view, I've always said at conferences and when I teach that it really comes down to the rules that Robert Fulghum set out for us in the wonderful book, All I Ever Needed to Learn, I Learned in Kindergarten. Share the toys, you know, make sure you keep the sand in the sandbox, and always remember to flush the toilet. And it's, again, I'm not trying to minimize that, but what we're working with is we learn as young people certain standards, and we learn to treat people with fairness and reasonableness and decency and respect. And those rules don't go away once one's in the workplace. And in fact, they need to be nurtured by both employers and employees. And I think that performance management is one of the best ways in which to do it, because often if you are genuinely performance managing someone, you are going to get the desired results. It's when you don't that you will not. Are there any further questions that have come in? I just want to take a look to make sure we've captured everybody's question. Oh, a question I've been asked about performance management is, you know, can you dismiss for just cause? Well, again, I go back to the issue. You can certainly do a paper trail that would maybe potentially satisfy a court in terms of you having tried every opportunity you can to improve this person's performance. Unless there is a very significant issue in respect of the performance via potentially attitude or behavior, and it involves a very serious issue, it is likely not going to sustain a just cause allegation, particularly if it's an employee of elderly years or who has been in the workplace for significant amounts of time. Typically, courts will look at this kind of situation and they will, you know, obviously understand that you've kept that employee for a certain amount of time, and the employee, in fact, has obviously done a good job up to that point. So what went wrong now? Perhaps it's time to end the employment relationship, just like a marriage. Things happen, things fall apart, and that's what happened. I do training quite a bit on performance management in the workplace, and it's often the case that when I'm doing sort of a group with all the management, that all of these issues arise, and managers say, but I don't have time to write things down. I don't have time to keep managing this. You've got to make the time. If you think it's worthwhile for the employee, you've got to make the time. A simple email will suffice, whereby you tell the employee and capture the essence of your discussion in that employee. So it doesn't have to be a long-winded letter, but it just has to say something about the essence of what you discussed. And obviously, the employee still has the ability to respond to that. And please, employers, if the employee responds and is improper in their response, then you need to respond to that. If you don't, silence will be interpreted as consent. Likewise, employees, if you feel that the employer has been unfair in that respect, you must respond as well. You must let the employee know, the employer know on paper that you feel that it's unfair and unreasonable. Again, simple concepts, but they make the difference in potential litigation. If you're an employer facing litigation from an employee, or employee, if you're an employee who's hoping to bring litigation because you feel that you've been wrongfully accused, wrongfully harassed, wrongfully bullied, not accommodated, or whatever the issue is, you need to have things in writing. And that's why the essence of my training sessions are usually called document, 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 because that is the only way in which to be able to win at trial and to be able to essentially, formulate a case persuasive to one party or the other that you will win at trial and hopefully resolve it after that. I would like to thank everyone today. I see that we're at the end of our time. I hope that you found this useful and helpful, and certainly I look forward to meeting with you again via our webinar the last Wednesday of each month, which we've decided is going to be the time that we will do the webinars. And I certainly wish everyone a great rest of the week. And particularly if you do have questions, very, very happy to answer them. And certainly please do feel free to email us at mcdonaldassociates.ca. And certainly my assistant will set up a consultation, delighted to do so. I hope you're all well. Thank you again. Have a good day.